Good morning. It's good to be with you. Welcome to our webinar on healthcare and life sciences. We haven't obviously been able to do this for quite some time now, but we decided that with things normalizing to a degree, we would bring our presentations back to you, dealing primarily with what it is that we're focusing on in the healthcare and life sciences area and sector, generally in South Africa. We've tried to select certain topics that are as topical as possible in the circumstances, bearing in mind that much has occurred globally over the past two years to 18 months in terms of how healthcare and life sciences law especially has developed and is changing in order to meet the demands that have been presented by COVID-19. It is a bit of a mixed bag this morning, but what we've, as I've said, what we've tried to focus on and concentrate on are issues and matters arising in this particular area of law that are topical and that we are increasingly seeing an interest in amongst you, our clients. Unfortunately, we can't obviously be in the same location and venue, and that is a great pity. It was always a wonderful experience seeing you all live and in person and trying to catch up for a change. We're going to be dealing with a couple of issues that we understand to be relatively pertinent at this point in time. We're going to be dealing with reviews in law, generally in principle, but also with reference to a particular decision that we were involved in, but was not published in the law report. So we thought it would be useful to highlight that issue and the matters that concern and pertain to reviews generally, which are becoming very popular in law at the moment, primarily because of the commercial interests that the government presents, especially in healthcare, with procurement and the acquisition of both goods and services. And then a more contentious and potentially debatable area, complementary medicines, ahead of a deadline that is set for 28 February of this year for licensing processes to commence, and discussing primarily what in fact is going on in respect of the regulation of complementary medicines and our approach generally to the obstacles to a degree, as well as the challenges that are presented by the current regulatory framework. And then address in broad detail the National Health Insurance Scheme and what we're expecting for 2022, based primarily on the contents of the existing National Health Insurance Bill. Whilst the program does indicate that questions will come at the end of the program, because of the very different topics we're going to cover, it would be probably better and more convenient for everybody if we have questions directly after each presentation. In that regard, we are going to use the Q&A function at the bottom of the screen if you'll type your question in there, and then we'll try and address those questions per speaker per topic at the end of each presentation. So I'm going to hand over now to Helen Michael, who is a director in the healthcare and life sciences practice area and a director in dispute resolution, which is the department into which we fall. And Helen is going to be discussing matters pertaining to reviews, as well as the judgment in the ILEX matter. Helen, over to you.
Thanks, Neil. Good morning, everyone. In my presentation, as Neil mentioned, I'm going to deal with a judgment that was handed down by the Gauteng Local Division in Johannesburg on the 15th of September 2020. The case deals with the challenge to a tender that was awarded by the government, which, as we all know, is unfortunately a type of litigation that has become all too common in South Africa. Before I get into the facts of the matter, I thought it might just be useful to understand generally the legal framework that applies to public procurement or tenders in South Africa, which is actually really highly regulated. So firstly, you've got section 217(1) of the Constitution, which requires all organs of state that contract for goods or services to do so in accordance with a system which is fair, equitable, transparent, competitive, and cost effective. Certain legislation has then been enacted to give effect to Section 217 of the Constitution. That legislation includes the PFMA, or the Public Finance Management Act, as well as the PPPFA, or the Preferential Procurement Policy Framework Act. Now, what these acts try to do is they reinforce and they flesh out the requirements for ensuring that public tenders are in fact transparent, fair, and competitive. In particular, they aim for a standard where organs of state are able to attract the highest number of bidders so that the states can get value for their money when purchasing goods and services. In other words, state money is supposed to be spent in an effective and efficient manner. Unfortunately, this process is not always followed, and where it's not followed, PAJA, or the Promotion of Administrative Justice Act, becomes relevant. Now, in terms of PAJA, the process by which a government tender is awarded constitutes administrative action. That term is defined in PAJA to include a decision by an organ of state that exercises public power, which adversely affects the rights of any person, and which has a direct external legal effect. PAJA then goes on to state that administrative action must be procedurally fair. Where the action is not fair, Section 6 of PAJA provides that a person may institute legal proceedings in a court for the judicial review of the administrative action. The grounds of review are also specifically set out in Section 6. I just note at this point that the central focus of a review is not whether the decision that was ultimately made was correct, but rather the process undertaken to get to that decision was procedurally unfair. Section 8 then sets out the remedies available in proceedings for judicial review and provides that a court may grant any order that is just and equitable, including an order setting aside the administrative action. Okay, so with that background in mind, let's turn to the case at hand. I've included the full citation of the case in the slides for ease of reference. It's also just important to note that the judgment was not appealed, and so the decision in the matter stands. Okay, so in this case, the applicant was ILEX South Africa, and ILEX instituted proceedings against the first respondent, which was the National Health Laboratory Service. The NHLS, as I'm sure you know, is a national public entity that is established in terms of national legislation, and its sole mandate is to provide pathology services to the National Department of Health. Then you have the second respondent, which was the CEO of the NHLS. The third respondent was Abbott Laboratories, and the fourth respondent was Roche Diagnostics. The third and fourth respondents were the successful bidders in this matter. Okay, so in this case, the NHLS issued a 1 billion rand request to tender for the supply of HIV and AIDS viral load testing equipment for a period of 3 years. ILEX was one of the unsuccessful tenderers, and it instituted the review proceedings. The relief sought by ILEX was for, amongst other things, an order declaring that the tender process undertaken by the NHLS was illegal, invalid, and unconstitutional. And secondly, an order setting aside the decision, as well as the contracts that were concluded with the successful bidders pursuant to that decision. And just from a timing perspective, the manner in which the matter progressed was as follows. Firstly, the NHLS made the decision to award the tender to the successful bidders in November 2018. The NHLS only notified the successful bidders of its decision in January 2019. Abbott then accepted the award in January, and following some negotiations, Roche accepted its award in March 2019. The award was then ultimately implemented in July 2019. In the interim, ILEX was advised that it was unsuccessful in February 2019, and it instituted the review application in May 2019. Now, notably, the application was not instituted on an urgent basis, and the matter was only heard in June 2020, with judgment being handed down in September of that year. The tender award was therefore being implemented for just under a year before the matter was actually heard in court. Now, in terms of the grounds in which ILEX challenged the decision, the two main grounds were, firstly, ILEX alleged that the bids of the successful tenderers were accepted by the NHLS only after the relevant acceptance period had expired, which rendered the acceptance void. And secondly, ILEX challenged its disqualification from the tender, which was based on a particular interpretation of the requirements for the pricing criteria. The background to the first argument was that the closing date for submissions of tenders was the 11th of June 2018. The bids of tenderers then remained open for acceptance by the NHLS for a period of 120 days from the date of submission, being the 9th of October 2018. However, by 9 October, the NHLS had not yet accepted any offers, and on the next day, the NHLS decided to extend the bid acceptance period for another 120 days. However, ILEX argued that the NHLS was not entitled to extend the bid validity period after the extension period had already expired. The argument was therefore that the extension was invalid, and therefore the decision was invalid. The court ultimately accepted the arguments put forward by ILEX on this ground and ruled that the NHLS could not have taken any decision after the bid validity period had expired. Instead, and in terms of procurement law, the NHLS was required to re-advertise the tender. In relation to the argument concerning ILEX's disqualification, which was quite technical in nature, in essence, ILEX was disqualified for providing annual pricing quotes for the services to be rendered, whereas the NHLS had indicated that bidders were required to reflect the total price for the goods and services for the entire 3-year contract period. ILEX argued that its disqualification was based on a technicality, and accordingly, the NHLS acted irrationally and unfairly. The court also ruled in favor of ILEX on this ground on the basis that the pricing documents of the tender created vagueness and uncertainty, and as such, ILEX's disqualification was unlawful. The court therefore ultimately ruled that the award of the tender was indeed an unlawful exercise of state power. The question that the court was then required to deal with was, well, what's an appropriate remedy in the circumstances? And this is where this all gets quite interesting. Instinctively, one would assume that if a decision is found to be unlawful, then a court should set that decision aside, with the result being that a new fair and lawful tender process is initiated. Well, it's actually not as simple as that. To explain this difficulty, the court referred to a judgment of the SCA in Millennium Waste Management versus the Tender Board of Limpopo. I've quoted the relevant paragraph of that case in this presentation, as I think it quite clearly explains the conundrum that courts often find themselves in. According to the SCA, the difficulty that is presented by invalid administrative acts is that they often have been acted upon by the time they are brought under review. That difficulty is particularly acute when a decision is taken to accept a tender. A decision to accept a tender is almost always acted upon immediately by the conclusion of a contract with the tenderer, and that is often immediately followed by further contracts concluded by the tenderer in executing the contract. To set aside the decision to accept the tender, with the effect that the contract is rendered void from the outset, can have catastrophic consequences for an innocent tenderer and adverse consequences for the public at large, in whose interests the administrative body or official purported to act. Those interests must be carefully weighed against those of the disappointed tenderer if an order is to be made that is just and equitable. So it's quite clear that there's a lot more to think about when a court is tasked with formulating a remedy in cases like these. And ultimately, it's a question of balancing the competing interests of the unsuccessful tenderers, the innocent successful tenderers, as well as the public at large. Courts therefore have a discretion to determine a just and equitable remedy. That discretion not only appears in PAJA, as we've discussed earlier, but also in section 172(1)(b) of the Constitution. Section 172 becomes relevant as every improper performance of an administrative function implicates the Constitution, and in particular 217 of the Constitution. A court is therefore constitutionally authorized, once it has found conduct to be unlawful, to craft an order that is appropriate in the circumstances. In this case, the court considered the circumstances, noting that the remedy must fit the injury and must be fair to those affected. With that approach in mind, the court firstly considered the national importance of the services that were at that stage already being provided by the successful tenderers for just under a year, as well as the possible disruption that would be caused if the decision was set aside. The court remarked in this regard that there can be no doubt that immense disruption would be caused with dire consequences to millions of South Africans living with AIDS if the contracts concluded by the NHLS with Roche and Abbott were to be summarily set aside. The court went on to say that it's unthinkable that that should occur. The court also considered the interests of the public and said that the HIV load test should, without question, be carried out without interruption. The court also noted that the successful tenderers in the matter in no way contributed to the unlawfulness of the tender process. And finally, the court considered the effect on the public purse in the event that the tender award was set aside and the tender was reissued. In particular, the question that the court asked was whether its retender would cost the NHLS more than it was at that point paying for the relevant services. On this point, the NHLS had noted that even if Alex was not disqualified when it was, Alex would have still scored the least number of points compared to successful tenderers, which in turn means that its tender would have in any event been unsuccessful. The point was therefore that even if the tender was redone, it was unlikely that the process would result in the state entity receiving a more cost-effective solution. The court therefore recognized that there may be significant financial benefits to not setting aside the contracts, despite the fact that they were tainted by constitutional invalidity. Insofar as the remedy was concerned, the court therefore held that the circumstances of the present case were such that it falls within the category of those cases where, by the reason of the effluxion of time and other considerations, notably the fact that there is a real possibility that if the defect is remedied by the completion of the tender process, the result would be the same. Therefore, an invalid administrative act must be permitted to stand. The court therefore exercised its discretion in favor of declining to set aside the awards, notwithstanding the fact that it found the awards to be unlawful and constitutionally invalid. So ultimately, in terms of the order of court, the court ruled that the decision was unlawful, but it elected to not set the decision aside. Now, to make things even worse for Alex, we have a general principle in our law that says that successful parties in a court matter should be given their costs. The court ruled that the respondents were substantially successful in this matter, and therefore Alex was ordered to pay the legal costs incurred by the respondents in opposing the matter. So I think just from our side, the key takeaways from this presentation are firstly that where a public tender is awarded unlawfully, the right to just administrative action of the unsuccessful tenderers is infringed, and those tenderers may then institute review proceedings to declare the award unlawful. The infringement of rights is obviously even more tangible where, but for the unlawful tender award, an unsuccessful tenderer would have received the tender. The court, however, has a discretion to determine a just and equitable remedy. And unfortunately for the wronged tenderer, when considering a just and equitable remedy, the court does not focus solely or even primarily on the interests of the wronged tenderer. Instead, the courts take into account the broader interests, or particularly of the public if the award is set aside. The court's discretionary power should therefore be taken into account if you are considering challenging a tender award, as you may end up with a remediless review and a bitter taste in your mouth. Just from a practical perspective, as you've seen, one of the main factors that affects public interest matters of this nature is the effluxion of time. In other words, where an unlawful tender award has already been implemented, it is particularly difficult to obtain an order setting that award aside, as the result will likely be a substantial disruption to important services. It's therefore important to act fast in these types of matters and to be proactive when engaging with organs of state to ensure that there is no delay in challenging an award when necessary. Thanks, everyone.
Thanks, Helen. I don't know if there are any questions following that presentation. I don't see any at this point, but we will, if needs be, we can deal with questions toward the end of the presentations. Turning now to complementary medicines, may I introduce Boita Melamoti, who is an associate in the healthcare and life sciences practice area. And Tumi will be dealing with matters pertaining to the complementary medicines and their regulation in the current legislative landscape. Tumi, over to you.
So my name is Guideline Melamoti, as Neil has said. I am an associate in the Healthcare and Life Sciences Department, working alongside Neil and Helen. And mine is a very short and sweet one, hopefully. I will be addressing you on the status of the regulation of complementary medicine in the current legislative framework. So I think a good place to start would be the establishment of category D of medicines. If I can just find my moving button. Nishka, can you assist with moving the slides, because there seems to be a problem on my side? Thank you. Yes, so a good place to start would be the establishment of category D of medicines with the publication of the General Medicine Regulations, which were published by the Minister of Health on 25th of August 2017. And I'll be referring to these regulations as either the general regulations or the regulations throughout my presentation. And the regulations introduced the definition of complementary medicines and health supplements, which are listed in Regulation 9 as Category D, medicines which are intended for human use and for use in animals without further manipulation and which are ready for administration. So for the sake of brevity, I did not include the definitions in my slides, but I think it would be useful for me to take you through the definitions just so we can note what the commotion is about. So the term complementary medicine is defined in the regulations as any substance or mixture of substances that is of natural origin, that is substances that are derived from, for example, plants, animals, minerals, and so forth, and that are used or purporting to be used or suitable for use or manufactured or sold in maintaining, complementing, assisting, or assisting the physical or mental state of a user. And all are used to diagnose, treat, mitigate, or modify or alleviate or prevent any disease, illness, or symptoms, and are used as health supplements or in accordance with the disciplines that are determined by SAHPRA as the regulator. So of this definition, there are two problematic areas that I've noted. Firstly, this definition is wide and it includes the health supplements in its definition, and it also includes a wide variety of products that are not normally contained as medicines as per the definition contained in Section 1 of the Medicines Act. The definition of health supplements is that any substance, extract, or mixture as determined by SAHPRA, sold in dosage form that is used or purported to be used in restoring, correcting, or modifying any physical or mental state of a user by complementing such user's health or supplementing diet and adding a nutritional value to such user. This covers, like I said, a whole range of products that are not medicines as defined in the Medicines Act. And with the introduction of these medicines, these definitions rather, SAHPRA is trying to classify complementary medicines as Schedule 1 substances. This you will note in the definition of health supplements, which excludes injectables, medicines, or substances listed in Schedule 1 or higher of the Medicines Act. The implications of the regulations is that the definition of complementary medicine and health supplements are drafted so broadly to incorporate complementary medicines and health supplements that would not necessarily fall within the regulation as contained in the Medicines Act. And this is exactly what was discussed in the judgment, sorry. In the judgment of the High Court of South Africa, the Pretoria Division of the High Court, in a matter of Alliance of Natural Health Products versus the Minister of Health and SAPRA being the second defendant in that matter. The particular issue that was discussed or that centered the application was that the definitions of complementary medicine and health supplements as contained in the regulations. And I'll be referring to this judgment as the ANHP judgment throughout my presentation, just for ease of reference. And according to Alliance Natural Health Products in South Africa, the definition of complementary medicine and health supplements are drafted so broadly so as to incorporate complementary medicines and health supplements that do not fall within the ambit of medicine. So the very issue that I noted earlier on was at the core of this application. So Alliance of Natural Health Products South Africa contended that the regulations, and in particular the definitions that I discussed earlier, include products that should not be included in the ambit of the Medicines Act and should therefore not be regulated as envisaged in the regulations. These aforementioned products, according to the Alliance of Natural Health Products, are now included as complementary medicines and health supplements, whilst in effect, they do not contain any surgical substances, they make no therapeutic or curative claims, and these products only claim to promote the well-being and good health or promote relaxation of users. In this sense, these products are qualitatively different from medicines which are designated and dispensed solely to target therapeutic purposes and to treat or cure maladies. According to the Alliance of Natural Health Products, the minister, in making the regulations, acted ultra vires, and the regulations are thus unlawful. So the respondents in the matter, being the minister and SAPRA, argued that the definition of medicines in the Medicines Act is wide enough to include complementary medicines and by implication natural health supplements. The court was therefore called upon to decide on whether or not the definition of medicines of medicine in the Medicines Act should be interpreted widely to include complementary medicine and health supplements as defined in the regulations. So the matter was heard by Judge Kabushi, sorry, and he ultimately ruled in favor of Alliance of Natural Health Products. And in this regard, Judge Kabushi held that the Medicines Act does not empower the minister to regulate all complementary medicines, and that for complementary medicines to fall within the proper contextual definition of medicine as defined in the Medicines Act, only those products that purport to be suitable for use, manufactured or sold for therapeutic purposes and to prevent and treat a malady may be regulated. The judge further held that the broad definition of complementary medicines and health supplements in the regulations may be interpreted to include complementary medicines and health supplements that do not purport to address or diagnose or treat or mitigate any physical or mental health disease. The regulations accordingly, this is what the judge held, are ultra vires, and to the extent that the regulations apply to complementary medicines and health supplements that are not medicines or scheduled substances as defined in Section 1 of the Medicines Act, are declared unlawful and therefore invalid. The court ultimately decided to strike out the regulations insofar as they relate to complementary medicines and health supplements that are not medicines as defined in Section 1 of the Medicines Act. The declaration of this invalidity, however, was suspended for a period of 12 months in order to allow SAHPRA and the minister to take the necessary steps and to determine the best manner in which to regulate categorized complementary medicines. So where we are with the judgment right now is that the Minister of Health has lodged an appeal against the ANHP judgment with the Supreme Court of Appeal. And this appeal is scheduled to be heard on the 7th of March, 2022. So this year, next month. And we thus can anticipate judgment in this regard in the second half of this year, about June. I've calculated, I think, June, July. But pending the determination of the appeal, all products that fall within the definition of complementary medicine and health supplements must therefore continue to comply with the current iteration of the regulations and the Medicines Act. And this includes compliance with the licensing requirements in terms of Section 22C and the provisions of Regulation 10, 11, and 12, which require that all medicines falling under Category D must comply with the prescribed labeling requirements, and Section 20, which deal with advertising and marketing of complementary medicines, and the requirement to submit all complementary medicines for registration as and when call-up notices are issued in terms of Section 14 of the Medicines Act. So this leads us to our next topic, which is the guidelines that have been published by SAHPRA. These guidelines they are a way of SAHPRA giving us guidance on how they will classify certain products or substances as complementary medicines. It is currently unclear which products will be classified exactly as complementary medicines or health supplements, and the guidance, like I said, is the only guidance that we have. So the purpose of the guideline is stated in the introductory paragraph of the guideline as to provide a clear guidance with regard to the safety and efficacy requirements for registration of health supplements as a subset or subclass of complementary medicine in South Africa. So how the health supplements guideline assesses that SAHPRA has provided us with annexure A to N, and these I will refer to as annexures. And these annexures list substances that may typically be considered as health supplements, which include vitamins, minerals, and probiotic. The list is very, it mirrors to a great extent the subclasses of health supplements as listed in item 34 of annexure 1 of the regulations. The health supplements guideline provide that the following substances are excluded from being regarded as health supplements for purposes of the regulation. So injectable substances would be excluded, substances that are in Schedule 1 or higher, listed in Schedule 1 or higher, and that are intended for those purposes as listed in those schedules, substances that are not specified in the list of included substances unless they are duly motivated. So these are substances that are listed in the annexures itself. So if you have a substance that is not included in the annexures, then you would have to motivate to SAHPRA as to why your product needs to be considered as or classified as a health supplement. And isolated active ingredients that are not provided for in the annexures, which is a similar thing. If it's not included in the annexures, SAHPRA would require some form of motivation from you in order to classify your product as a health supplement. Given that the law relating to complementary medicines and health supplements in South Africa is currently in a state of flux, we are awaiting the appeal. We cannot with absolute certainty predict how the regulator, SAHPRA, will classify specific products. So what I usually do when we are requested by a client to furnish an opinion on whether a specific product will be classified as a health supplement, in South Africa, I break down and analyze each and every ingredient contained in the product. And I also analyze the label to see if there are any claims made on the labeling of the product. And I then determine the probability of these products being classified as health supplements when I view it against the information provided in the guidelines. The difficulty we face is that, as we have seen, SAHPRA can chop and change these guidelines as and when they please, and SAHPRA will ultimately be hold the sole discretion in determining how a product should be classified. So we can't conclusively say that your product will be a health supplement. We can only provide a probability based on what the guidelines tells us. And lastly, SAHPRA has published a guideline. They initially published this guideline being the roadmap and transitional process for the regulation of complementary medicines in November 2018 in order to establish a new timeline for in respect of licensing and registration of complementary medicines. This guideline has been updated, and the latest version is the December 2021 version, and it contains a host of deadlines that are applicable to manufacturers, importers, wholesalers, and distributors of complementary medicines. So the first of these guidelines, these timelines is the looming 28 April 2022 deadline, which SAHPRA has provided for the application of licenses to manufacture, import, or wholesale or distribute complementary medicines. This is an online process, and they've given a deadline from, I think the process started in February 2020, and it will end in February 2022, the 28th of February 2022, which is next week by my calculations. Then we will have a deadline on the 1st of March then we'll have a deadline on the 1st of March for importers and manufacturers and wholesalers to only sell and distribute medicines and import and export medicines if they hold a license, or if they have submitted an application in terms of the deadline, which was provided of 28 April 2022. So from the 1st of March 2022, you will either be required to hold a license or to have submitted your application to hold a license before you either manufacture, export or import or wholesale or distribute complementary medicine. In July 2022, all the existing applications for registrations will be finalized, and once licenses are issued, then the registration process will commence. SAHPRA has indicated that they might publish call-up notices in terms of section 14 of the Medicines Act within 6 months to 72 months from July 2022, and they will then pilot the online application process for registration of category D medicines. So from July 2022, what's going to happen is that SAHPRA, within 6 months or 72 months, which is a very long period that they've given themselves, they will call up the registration of complementary medicines, and then they will also pilot the online process of registering these medicines, these complementary medicines. From 1 March 2023, you will be required to comply with the labeling requirements for category D medicines, which are complementary medicines and health supplements. And because of the appeal that is pending, we anticipate that this process, all the timelines that I have just discussed with you, are going to be revised in all probability, because once in June we find out whether the regulations are valid or not, then they might have to push all these deadlines forward. A question might arise on whether it is an absolute must to comply with these deadlines, and a discussion amongst ourselves is that while we wouldn't advise you not to comply with the deadlines, because ultimately it should be a commercial decision as to whether you register for licensing or not, because SAHPRA then ultimately has free reign on what to do with your products if you import such products to South Africa without the necessary license. It would lead to dire implications for your products. So we would encourage all our clients to actually comply with these deadlines. And that's the end of my presentation. Thank you very much.
Thanks, Tumi. I don't know if there are any questions arising from that presentation. I don't see any at this point in time. Right. I think that's over to me. I am going to be dealing with the National Health Insurance Scheme and what we may expect of that process during the course of 2022, bearing in mind that ultimately this process is one that has commenced and begun quite a while back now. A lot of people have accused me of being against a national health insurance scheme based on my comments in the media. However, I think that one needs to draw a distinction between what it is that the National Health Insurance Scheme is intending to achieve and the manner in which one is going about achieving that. Centrally, the NHI revolves around universal access to healthcare. That's what the bill talks about. And I think that that, as a concept and a principle, is something that you really can't debate. It is important that ultimately, as South Africans, especially over the course of the last 18 months, we understand that access to universal healthcare or universal access to healthcare is critical to our commercial survival, as well as the ability of our society to sustain itself from a healthcare perspective. So I'm not going to deride at any point in time the utility of universal access to healthcare services. I think one needs to look very carefully at what it is that we're doing about achieving that, and the processes and the structures that are being put into place in order to achieve that particular access. The current status of the process is one that is iterative. It is at this point in time, even during the course of this week on the 15th and the 16th, one where public comments are still being obtained by the Parliamentary Portfolio Committee on Health. So we are taking a detailed process for purposes of ensuring that there is meaningful public participation. And we are in so doing trying to endeavor that all interested and affected parties and stakeholders are able then to voice their concerns or even their compliments about what is proposed in the National Health Insurance Bill for purposes of trying to achieve its objectives. So that process has been ongoing since last year, in fact, and it is one that consists both of the submission of written comments, which occurred prior to the convening of the Parliamentary Portfolio Committee on Health, initiating hearings on the bill. And the hearings have been dense. There's almost been 20 days of hearings to date, and the comments have been widely detailed in terms of what people and institutions, companies and individuals think about what it is that the National Health Insurance Bill should be doing. The majority of those comments, as I've read what has been produced as minutes of those meetings, revolve around concerns relating to primarily governance, bearing in mind that the National Health Insurance Bill creates a vast architecture of institutions and agencies that are going to be established to manage the National Health Insurance scheme, not only the National Health Insurance Fund. Also, a lack of detail, which is an ongoing issue of the benefits that are going to be provided, as well as the legal status of the mandatory prepayment scheme and how that is ultimately going to work. What is interesting for purposes of understanding the process, in my view, is that if one examines the bill, it contains within its own structures, bearing in mind that this is a bit of an anomaly in the bill, it contains clauses that deal with phases through which the bill is to proceed, or the process is to proceed for the construction of the National Health Insurance Scheme. Now, Clause 57 is the clause that really is the anomalous clause in this bill, because it almost operates on the basis that it is in force, because it sets out time periods in great detail concerning the phases through which we are going to move for purposes of establishing the National Health Insurance Scheme. Now, I say it's an anomaly because it is quite odd for a bill, which is not enforceable legislation, to contain time periods that are currently in force or currently running, and through which the construction of the scheme is to proceed. Now, I'm not certain what the thinking was behind including Clause 57 in the bill with those detailed time periods, but we, at this point in time, are not really seeing too much in the way of adherence to what it is that those time periods tell us and how those clauses in the bill actually function and work. So from that point of view, we are at this stage at the end of phase one. So we were told, or are told in the bill, notwithstanding the fact that we are still running through a public participation process, that phase one has had to be completed by the end of 2022. It was a phase that was going to be for 5 years, beginning in 2017, and it was designed and intended to deal with the implementation of health system strengthening. Certain initiatives were going to be developed in order to strengthen the health system. I'm not certain I've seen any of those particular initiatives. The development of national health insurance legislation, as well as the consequential amendments that would be required to other healthcare legislation in order to accommodate those changes to ensure the establishment of the fund, as well as undertaking initiatives aimed at establishing institutions for the foundation of the fund, and the purchasing of personal healthcare services for vulnerable groups such as children, women, people with disabilities, and the elderly. Now, I accept that during the course of 2017-2022, a large portion of that time period was dedicated to COVID-19, and resources and attention were rightly diverted to dealing with that particular issue. So it may be argued that we were outside of that time period irrespective because of the intervention of the COVID-19 pandemic. But where does that actually now leave us? Because we are told in clause 57.5 that we're now formally in phase 2 of the process, and that is a 4-year period from 2022 to 2026. So conceivably, on the face of the bill, we've completed phase 1 and we are now in phase 2. And once again, please bear in mind that we are still grappling with issues pertaining to the public participation process. Now, phase 2 talks about the continuation of the health system strengthening initiatives, the mobilization of additional resources where necessary, and the selective contracting of healthcare services from private providers. Now, the chances, in my view, of that occurring at this stage, based on the processes that we are seeing, are relatively slim, which then obviously raises the question as to, well, what does clause 57 try and achieve, and how, in fact, are we going to be assessing whether or not there is compliance with the phases through which the bill tells us this entire process is to move. Well, that's going to be difficult to determine. It appears that clause 57 is going to be largely ignored in relation to the way in which we are seeing the construction of a national health insurance scheme occur. That too is influenced by the public participation process, because presumably within the context of what is going on now, the public participation process must, in my view, produce amendments to the current bill. It must produce a reiteration of the existing bill for purposes of further analysis, both by members of the public as well as by Parliament and the legislative process through which the bill is going to have to move. Clause 57 also does provide a great deal of detail concerning what has to be established, or what was supposed to be established in phase 1, as well as the objectives that were to be achieved in phase 1. Phase 2 doesn't attract as much attention and detail in the bill. In clause 57.5, it's simply stated that the objectives of phase 2 include the establishment and operationalization of the fund as a purchaser of healthcare services through a system of mandatory prepayment. Now, that mandatory prepayment obviously is the rub, where everybody will have to contribute in one form or another to the fund in order for the fund to be established, as well as to maintain the fund. So as I've mentioned, we're now undergoing a public participation process primarily organized and orchestrated by the Parliamentary Portfolio Committee on Health. That process is being minuted, and those minutes are generally available from the parliamentary reporter. I expect that the process must be one where those comments must be taken into account, and in all likelihood, once the Parliamentary Portfolio Committee process ends, there should then be a distillation phase where the comments are looked at, analyzed, and responded to meaningfully. I understand that should occur during the course of this year, potentially in April 2022, depending largely on the ability of the Parliamentary Portfolio Committee to process the degree of comments that they have received, and also then to draft whatever is needed based on those comments in order to address those comments in the context of the bill. I also would then expect that as a result of that process, that there would then be a republication of a version of the bill that would then reflect the comments that have been made, as well as refine certain aspects of the bill and also of the scheme and the fund as proposed. I don't believe that it would be a useful process to follow, where you have a public participation process to this degree and then nothing is produced as a result in terms of a reiteration of the contents of the bill. To me, that would fall short of procedurally fair administrative justice, something that Helen has discussed and the provisions of both Section 33 of the Constitution, which deals with the right to procedurally fair administrative justice, as well as the provisions of the Promotion of Administrative Justice Act. So the process that is outlined in the bill in clause 57 is not one that I think lines up neatly with what in fact has to occur practically and legally for purposes of dealing with the bill and the public participation process that is and has been required. So at this point in time, whilst there are a range of issues that do need to be dealt with, the future of the process is one that is largely darkened by the lack of detail in the timing that is to occur in respect of the process, as well as the muddling that has occurred as a result of the inclusion of clause 57 in the bill as it stands currently. In my view, as I've stated, I think that we still have to go through a number of rounds of drafts of the bill in order to ensure that the fund and the scheme as proposed are refined, that they align with our current healthcare realities, as well as what it is that we're wanting to achieve into the future for purposes of addressing priorities based on our local South African burden of disease, as well as the healthcare priorities that may have shifted as a result of the pressure applied onto our healthcare system by COVID-19 and the pandemic, which as we keep being told is far from over. So the future and the legislative process, I think, are far from over. I think that the future of this bill must be in the devil and the detail that will be produced as a result of the comments that have been provided on the bill, and also the debate that we still need to have about the ability of the Department of Health, together with the National Treasury, to make funds available so as to establish the fund and all of the other structures that are designed and intended according to the bill to support the fund. And that, I think, is going to take some time. If one is to ask me what I thought the timing would be, I don't foresee during the course of 2022 the coming into law of the National Health Insurance Scheme legislation. I think it's going to take some time, as I've said, for all of this to come to a point where it makes sense and for it to align with what it is that we need as a fund and what priorities, as I've said, we need to address from a healthcare perspective. So unfortunately, whilst the bill within itself is something that we need to look at more carefully, I think that the overall effect is one of waiting for the processes that are currently afoot to complete themselves, and then to allow those processes to produce results that show that this has been an engaging process, that it is one where public concerns and comments have been taken into account, and one that indicates and at least gives us some degree of assurance that whatever legislation is to be produced for purposes of establishing a national health insurance fund and scheme are constitutionally aligned, and that we have at least that comfort that the constitutionality of whatever legislation is produced is going to operate to protect ordinary citizens, and hopefully in the course of that advance what this bill intends to achieve, which is creating universal access to healthcare services in one form or another. There are a number of commercial interests that need to be taken into account. There are a number of sectors and areas that need to be adjusted, especially within the context of things like private funding, medical schemes, short-term insurers, and associated products, because those continue to remain a feature of the South African healthcare landscape. Those constituencies and those persons will need to have their concerns assuaged by whatever is produced in terms of draft legislation. And hopefully the clarity that we've been asking for some time now as to the interaction between public and private sectors, as well as the existing healthcare sector, both public and private, will then be addressed, and the clarity produced in the bill in due course to allow us to understand how into the future those sectors are going to interact with each other, and how ordinary citizens as consumers of healthcare are then going to be able to access and produce their healthcare services, as well as consume those healthcare services to the interests of promoting overall a healthier society in South Africa, notwithstanding, unfortunately, the provisions or the consequences of the COVID-19 pandemic. I have barked on a bit about national health insurance in the media. I'm probably going to continue barking on about that for a while until we see some degree of progress from a legislative point of view. And hopefully, and I really do hope that we are able to see something of an iteration or a new draft of this bill in order for us to at least address, hopefully, the concerns that have been raised historically. Thanks very much. I don't know if there are any questions. There is one. Is a revised bill likely to be released sometime this year before the ANC conference? Would a delay not benefit a more realistic and appropriate draft that speaks to needs? Yes, I think that I'm not certain that the bill is going to be released prior to the ANC conference. Obviously, from a political point of view, it would be a political gain for the ruling party to indicate that it is dedicated to the process of national health insurance. I think that it probably would be. I would like to see that degree of action, as well as that kind of timing. Whether a delay would not benefit a more realistic and appropriate draft that speaks to needs, well, I don't know. I think that that's going to be largely determined by what we see in a revised draft, as well as the political will that runs around that. If there is indeed an interest in achieving a draft that meets the needs of everybody concerned, and if that's possible, bearing in mind the range of constituencies involved, I think that, well, I suppose then a delay may be more realistic in the circumstances in order to achieve consensus. The second question was, Discovery has come out strongly in support of a blended model. Is this likely to be included in the draft? Well, yeah, I suppose it may very well be. I think that there has been some friction in the draft, clause 33 especially, insofar as the interaction of the national health insurance scheme and the existing medical scheme industry is concerned, where there is uncertainty as to what medical schemes will be able to provide post the introduction of the fund, where at this point in time it's a complementary service, which no one is quite certain what it means. But I think that we'll probably and hopefully see some shift in clause 33, where it's either elaborated upon or clarified in respect of how that interaction is to occur and what medical schemes will in fact do under a national health insurance fund. Third question, do you think the redraft will address concerns around governance and risks of corruption, as well as the current public procurement incidents that are greatly concerning? Yes, I think that has to happen, because that seems to have been a point of emphasis during the public participation process, where concerns were raised about creating another public entity that would control vast amounts of money in circumstances where you are creating numerous agencies, committees, and authorities to operate this fund, and each of which will require not only a budget, but also then begin to look at things like how money is spent by the fund. So I think that there has to be an understanding that if you are going to create these structures and these agencies in the National Health Insurance Bill, then there have to be stopgaps, checks and balances to deal with the potential for corruption to occur, as well as the interaction between the bill or the act that it will become and existing public procurement legislation. That does need to be refined, and we do need to have a proper understanding of how that money is to be spent under the bill, and or if, as it stands now, if it becomes an act, and how procurement is to occur by those agencies and committees and the fund at large, in order to ensure that we create something that is then not susceptible to the degree of corruption that we have seen, unfortunately, in other state-owned entities or other public entities that are not necessarily SOEs. So I'm hoping that the draft will, in fact, or a revised draft will, in fact, deal with directly how procurement is to occur and how corruption is going to be avoided in the context of this particular initiative. Okay. Is there any other questions? No, I don't see any. Anushka, do you see any further questions? I don't.
I don't. Neil, you can close. Oh, there is one more.
Okay. Is it likely that medical tax credits will be further reduced in the budget speech? I think that's a good question. I think it depends largely on what emphasis is being placed on this bill at the moment. I know it has featured in a couple of public remarks by the president. If there is some degree of, I suppose, serious agenda in relation to NHI, there may be a reduction in medical tax credits. It may be premature to have those credits reduced at this point in time, bearing in mind where the bill is in its process. But I think that if it becomes a reality, insofar as NHI progresses this time next year to a point where we're looking at an act where it's actually been passed by Parliament, then I think you'll probably will see that there will be fiscal adjustments made in order to accommodate NHI in the current context. So the short answer is maybe not this year, but depending on where we are next year with NHI, we may in fact see that change. I hope that answers the question. Great, thank you. Well, we're giving you some of your day back. I trust that that was of some degree of interest to you. We will make the presentation available, as well as the recording of these presentations available as well, so that you can have for posterity, and there's some degree of souvenir by which to remember us, hopefully. And yeah, thank you for your time. Thank you for joining us. We really do appreciate the loyalty amongst our clients and those interested in what it is that we have to say. Hopefully we'll have a further seminar during the course of later this year, depending on developments in the healthcare sector. And just one further question, do I foresee that other policies and legislature will be amended as well? Yes, I do foresee that, bearing in mind that the bill, as it currently stands, contains a schedule setting out all of the proposed amendments to existing healthcare legislation in order to allow the bill to fit into that legislative context. There may indeed be other changes to legislation where that legislation is not referred to in the schedule, but I haven't seen anything to that degree just yet. But that doesn't mean that we will not see those changes. I would predict that those changes would probably occur only once the bill has been finalized and passed by Parliament into law as an act. Right. Everybody, thank you. To my co-presenters, thank you very much for your time and your dedication. I appreciate it. And hopefully we'll see you in person very soon. Thanks for your time.